வணக்கம் தமிழீழம் ஐவான் இளைஞர்களே, மற்றொரு மக்கள் கருத்துக்களம் நிகழ்ச்சியில் சமகால அரசியல் கண்ணோட்டம் என்று நாங்கள் ஐநா சபையும் யுக்ரைன் ரஷ்யாவுக்கும் இடையில நடக்கின்ற போர்கள் இதை பற்றியும் பார்க்கறதுக்கு இருக்கின்றோம். இப்போது முதலாவதாக நாங்கள் ஐநா சபையில் இன்று 46 கீழ் 1 தீர்மானத்தில் அறிக்கை, அதாவது மனித உரிமை ஆணையாளரின் அறிக்கை வந்திருந்தது. அத்துடன் அந்த அறிக்கையினுடைய ஆங்கில பிரதியும் அத்துடன் இப்போது அந்த நேரடியாக ஐநா மனித உரிமை சபையில் நடத்தப்பட்ட அந்த நேர்முக இதையும் நாங்கள் கொண்டிருக்கின்றோம். அதற்கு பிறகு யுக்ரைன் போயிருக்கின்றோம் என்று கூறிக்கொண்டு இப்போது நாங்கள் நிகழ்ச்சிக்குள் போவோம்.
Pursuant to Council Resolution 46/1, it's my honour to welcome Ms. Michelle Bachelet, High Commissioner for Human Rights, to present her written update. You have the floor.
Perdón, la lista de oradores.
I beg your pardon, the list of speakers will close in 15 minutes. Thank you.
Gracias, señor presidente. Distinguished President, Excellencies, Council members have received a written update on Sri Lanka, A/HRC/49/9. It mainly focuses on developments since our previous report in February 2021 and demonstrates the vital need for the Council's continuing attention. There have been some recent signs of increased engagement by the government with OHCHR and certain steps to initiate reforms. The proposals to amend some provision of the Prevention of Terrorism Act and to release some detainees under the Act are welcome initial steps. I encourage the government to take further steps to address the fundamental problems with the PTA, as well as undertake the deeper legal, institutional, and security sector reforms that are critically needed to put an end to impunity and prevent any recurrence of past violations. Regrettably, the past year has also seen further obstruction and setbacks to accountability. Victims and their families continue to be denied trust, truth, and justice. And the government's response to criticism has constricted democratic and civic space, including for essential human rights advocacy. My February 2021 report identified a number of underlying trends that threaten human rights. These trends continue to advance. The militarization of civilian government functions is further deepening. I remain deeply concerned by the concentration of civilian positions in the hands of military officials, some of them implicated in serious allegations of human rights violations. The expression of ethno-religious nationalism in state institutions has become more visible, increasing the marginalization and fear of minority communities and undermining reconciliation. Since the end of 2020, we have noted a significant increase in land disputes, mainly related to Buddhist heritage conservation or forestry protection, that are exacerbating grievances of minority communities and creating new tensions. I regret the erosion of independence of countries' key commissions and institutions, including Sri Lanka's Human Rights Commission, subsequent to passage of the 20th Amendment to the Constitution. Victims' trust in the Office of Missing Persons, established to investigate the country's tens of thousands of enforced disappearances, is lacking. The forthcoming constitution drafting process will be an important test for the future independence of key institutions and should emphasize devolution and human rights. Excellencies, 2 years after the expression of commitments to pursue, and I will quote, inclusive, domestically designed and executed reconciliation and accountability process, end of quote, before this Council, the government has still not produced a credible roadmap on transitional justice towards accountability and reconciliation. I remain concerned by the continued suffering and anguish of victims and families of the disappeared, who call for truth and justice and seek to commemorate their loved ones. I urge the government to acknowledge their rights, urgently determine the fate or whereabouts of victims, bring perpetrators to justice, and provide reparations. Victims of the 2019 Easter Sunday bombings and religious leaders also continue to call for justice, reparation, and a full account of the circumstances of those attacks, in particular the role of the security establishment. I am also deeply concerned by continued reports of surveillance, harassment, and intimidation of civil society organizations, human rights defenders, and journalists by police and intelligence services. Repeated incidents of death in custody and in alleged armed encounters with police are alarming. We also continue to receive allegations of ill treatment and torture by police and military. This highlights the importance of fundamental security sector reform. Mr. President, our previous reports to the Council have detailed the failure of successive governments of Sri Lanka to prosecute international crime and serious human rights violations and to pursue an effective transitional justice process. The current government has not only demonstrated its unwillingness to pursue accountability, it has incorporated military officials implicated in alleged war crimes into the highest levels of government, reinforcing a narrative of impunity. For these reasons, and to provide some forms of redress for victims, I have called on the Council to pursue alternative strategies to advance accountability at the international level. Regarding our implementation of the accountability-related aspect of Resolution 46/1, preparatory work is underway. Our team will analyze the information that has been consolidated in the evidence repository using a criminal justice perspective, with a view to identifying gaps and priorities for further information collection and incorporating a victim-centered approach. I must note the considerable scale of the work required from my office, noting that it will require time, adequate human and financial resources, and cooperation by states, including to investigate and prosecute perpetrators of international crimes committed by all parties in Sri Lanka through judicial proceedings in their jurisdiction under accepted principles of extraterritorial or universal jurisdiction. The mandate under the Resolution 46/1 presents an important opportunity to pursue accountability for serious international crimes committed in Sri Lanka. This is a vital task. As long as impunity prevails, Sri Lanka will not achieve genuine reconciliation and sustainable peace. I thank you, Mr. President.
Muchas gracias.
Thank you very much, High Commissioner. We'll begin by hearing from the country concerned. I give the floor to the distinguished representative of Sri Lanka. Your Excellency, you have 5 minutes. Thank you.
Mr. President, the Resolution 46/1 on Sri Lanka was adopted by a divided vote in this Council. Sri Lanka and other member states opposed this resolution in fundamental disagreement with its deeply flawed procedure and unacceptable content, in particular its operative paragraph 6 regarding a so-called evidence-gathering mechanism. The resolution was directly contrary to the Council's founding principles of impartiality, objectivity, and non-selectivity. It went well beyond the mandate that member states conferred on it by UNGA Resolution 60/251. I have stated Sri Lanka's views on this matter to this Council on the 1st of March. We also submitted in a timely manner our comments on the High Commissioner's report. We note with regret that the Secretariat failed to publish this simultaneously with the High Commissioner's written update. Despite our rejection of the resolution, we will continue our voluntary international undertakings on human rights and engage with the United Nations, including with this Council. As stated by President Gotabaya Rajapaksa of Sri Lanka to our Parliament on the 18th of January 2022, we are a nation that respects international laws and conventions. We have regularly shared our progress and challenges in a candid and open exchange with this Council and other relevant organs of the United Nations system. We are convinced that there are serious anomalies and weaknesses in the report presented to this Council by the High Commissioner. The fundamental deficiency is its intolerably intrusive character, impinging as it does on core functions and responsibilities of organs of the Sri Lankan state, overwhelmingly mandated by the people of our country at 3 successive elections. There is as well a clearly discernible element of discrimination in that the Council would certainly not take it upon itself to embark on a similar inquisitorial procedure in respect of other member states. This in itself, Mr. President, strikes at the very root of the foundations of the United Nations system. The issue of uniformity and consistency of standards applied by the High Commissioner to member states, irrespective of their size and influence, and in steadfast conformity with the essential principle relating to the sovereign equality of all members of the United Nations fraternity, is cynically transgressed in several portions of this report. To our minds, this is particularly disturbing because the strength and prestige of the United Nations, and especially the Human Rights Council, derive from the widespread regard of the international community as a whole for the moral and ethical basis underpinning the attitudes of the Council. We fervently believe that this is vitally important to retain this confidence undiminished, especially having regard to the fate of the Human Rights Commission, the predecessor of this Council. It is a matter for deep regret that numerous instances of unsubstantiated allegations and superficial conclusions, insensitive to the complexity of ground situations, have found their way into the report. We have commented on these in extensive detail in our written response. We are dismayed by the High Commissioner's unwarranted onslaught on seminal institutions of our country, which function under the aegis of Sri Lanka's constitution and legal system, emanating from a rich and varied cultural heritage, and are subject to stringent review processes which form an integral part of our tried and tested laws. There is also the question of the use of stringently limited resources in such a manner as to achieve optimal benefit for all of humanity at a time of unprecedented crisis. The colossal expenditure of millions of dollars in a partisan and specifically targeted pursuit of Sri Lanka is hardly consonant with this obvious imperative. It seems to us a great pity that the report shows scant regard for these considerations, which appear to a wide swath of nations to be crucially important at this time. The government of Sri Lanka is firmly resolved to maintain the security and stability that we have restored for our people and ensure sustainable progress in an equitable manner. My country, Mr. President, reaches out to the international community with a sincere exhortation to join us as partners on a footing of equality and mutual respect to face the challenges ahead. I thank you, Mr. President.
Muchas gracias.
Thank you very much, Your Excellency. The list of speakers is now closed. I now invite interested delegations to ask questions of the High Commissioner and to make comments on the written update. And we'll begin with the European Union. You have the floor.
Mr. President, the EU thanks the High Commissioner for her update and welcomes the Office of the High Commissioner's work on accountability in line with Resolution 46/1. The EU acknowledges the proposed, though limited, reform of the Prevention of Terrorism Act and urges further efforts to bring it in line with international standards. We welcome the recent releases on bail related to the PTA and encourage further releases. We condemn the ongoing surveillance and harassment of civil society organizations, as well as the intimidation following a recent statement made by a representative of Sri Lanka's civil society before the European Parliament. We urge Sri Lanka to ensure a safe civic space, We welcome the transfer of the NGO Secretariat from the Ministry for Defense to the Ministry of Foreign Affairs, but regret that so far this has not led to concrete improvements for NGOs. We stress the importance of democratic space and strong and independent transnational justice institutions, such as the Office of the Missing Persons. Emblematic cases need to be addressed. Accountability must be ensured. We continue to be concerned about any form of discrimination against persons belonging to religious and ethnic minorities and call for inclusive dialogue with all. Madam High Commissioner, what concrete steps should Sri Lanka take to promote reconciliation and accountability? I thank you.
Gracias. Tiene la...
Thank you. I give the floor to the Netherlands on behalf of a group of countries.
I'm honored to deliver this statement on behalf of the 3 countries of the Benelux, Belgium, the Netherlands and Luxembourg. We thank OHCHR for its report on the human rights situation in Sri Lanka. We share the concerns of OHCHR on the erosion of democratic institutions, the independence of the judiciary, and the lack of accountability for past human rights violations. This not only undermines the democratic system, but also impedes reconciliation. President Rajapaksa mentioned his ambition to build a prosperous, stable and secure future for all Sri Lankans. The Benelux urges Sri Lanka to implement this and promote and protect the human rights of the people of Sri Lanka, including those of all minorities to this end. We know that the government of Sri Lanka has taken first steps to initiate reforms. However, we also see developments that undermine these steps and hamper deeper institutional reforms. There is a long road ahead, and the Benelux countries encourage the Sri Lankan government to fully cooperate with OHCHR and to ensure credible and tangible process in advancing reconciliation, accountability, and human rights. This is not only in the interest of the victims and survivors, but more generally of sustainable peace, prosperity, and justice in the country. We would like to ask the High Commissioner how the international community can best support the road towards reconciliation, including accountability for past human rights violations in Sri Lanka. We thank you.
Gracias. Tiene la...
Thank you. I give the floor to Norway on behalf of a group of countries.
Thank you, Mr. President. I have the honor of making this statement on behalf of the Nordic and Baltic countries. We thank the High Commissioner for her update, noting with regret the limited progress made on Council Resolution 46.1. We welcome the release on bail of Prevention of Terrorism Act prisoners, including Anaf Jassim and Hijaz Hizbullah, but remain concerned about others still in custody. We are encouraged by the move to amend the PTA. However, we are concerned that the proposed changes are insufficient to address human rights and due process concerns. We urge Sri Lankan authorities to ensure freedom of speech, including for human rights activists, journalists, and members of minority communities. We call upon the authorities to put an end to surveillance and intimidation of civil society, including arbitrary arrests. We are concerned about the lack of progress in the areas of transitional justice, accountability and reconciliation, and encourage the government to increase their efforts in this regard. We urge the government to ensure the independence and effectiveness of institutions dealing with these issues. We are also concerned about reports of deaths of persons in police custody and encourage proper investigation of these events. We call upon Sri Lanka to cooperate fully and effectively with the High Commissioner and the UN institutions to ensure full implementation of Council Resolution 46.1. Thank you, Mr. President.
Thank you, Ambassador. Tiene la palabra.
I give the floor to the United Kingdom by video.
This statement is by the Sri Lanka Core Group comprising Canada, Germany, North Macedonia, Malawi, Montenegro, the United Kingdom and the United States. We thank the High Commissioner for her update. We acknowledge first steps by Sri Lanka to address key reforms, but note that progress since Council Resolution 46/1 is limited. In particular, slow progress by the Office of Missing Persons in fully investigating cases since the release of the preliminary list of missing persons is troubling. Our concerns over surveillance and intimidation of civil society persist, and detentions, threats and intimidation of journalists and human rights defenders continue. It is crucial that civic space remains open. The releases on bail of Anaf Jassim and Hijaz Hizbullah are welcome as our first efforts to bring the Prevention of Terrorism Act in line with international human rights law. But the proposed changes to the PTA are very limited and our long-standing concerns remain. The new One Country, One Law Task Force risks undermining Sri Lanka's pluralist society. We urge Sri Lanka to ensure that this task force work is inclusive and non-discriminatory. We call for full cooperation with the High Commissioner and remain ready to support the government on the implementation of Resolution 46/1.
Thank you. Tiene la palabra.
I give the floor to Saudi Arabia on behalf of a group of countries by video.
Mr. President, the countries of the Gulf of Cooperation Council took note of the report of the OHCHR on Sri Lanka, and we thank the government for its efforts to promote human rights and for its cooperation with the Human Rights Council mechanisms. Mr. President, our country's delegations works that reports should be based on reliable, objective, and neutral information, and we stress that the reinforcement of human rights requires constructive cooperation and dialogue with the concerned country, because it's this country which is responsible for the reinforcement and protection of human rights on its soil. We reaffirm commitment to international principles like universality, non-selectivity, objectivity, and non-politicization when dealing with human rights situations. And thank you, Mr. President.
Gracias. Tiene la palabra.
Thank you. I give the floor to Germany.
Mr. President, Germany aligns itself with the EU statement. Germany remains strongly committed to human rights, reconciliation and accountability in Sri Lanka. We welcome initial steps forward, like the proposed amendments of the Prevention of Terrorism Act and the recent releases on bail. However, more comprehensive reforms are urgently needed to bring counter-terrorism legislation in line with international standards and allow civil society to operate freely and safely. We are deeply concerned about the independence of key institutions, namely the Office of Missing Persons and the Office for Reparations, as well as of the National Human Rights Commission. The rights of religious minorities and all communities must be protected. More inclusive governance is needed to strengthen human rights, reconciliation and accountability. Attacks against human rights defenders are unacceptable. Safe and open space must be ensured, also for dissent. We reiterate our strong conviction that ensuring accountability and justice for victims and survivors is essential for genuine reconciliation and sustainable peace. Madam High Commissioner, how can human rights defenders be better protected? Thank you.
Gracias. Tiene la palabra.
Thank you. I give the floor to Egypt.
We take note of the report by the OHCHR on Sri Lanka, and we reaffirm the importance to be committed to principles of universality, objectivity, non-selectivity, and to do away with double standards when dealing with human rights issues, while refraining from politicizing them and using them to intervene in the political affairs, internal affairs of countries, while attaching importance to building the capacity of national institutions and technical cooperation. We stress that the Council and the OHCHR to continue efforts to improve cooperation and dialogue with concerned countries when dealing with resolutions that concern them in order to achieve a positive outcome and to provide support in line with national priorities and with full respect of its sovereignty. And thank you, Mr. President.
Gracias.
Thank you. I give the floor to Montenegro.
Thank you, Mr. President. Montenegro has already expressed some of its key stance as a member of the Sri Lanka Core Group. We welcome the initial steps of the government to address some key issues related to the legal, institutional and security reforms. A more comprehensive and deeper reform agenda, however, is needed for Sri Lanka to comply with its international obligations and to prevent a recurrence of grave human rights violations. We emphasize that the upcoming constitutional process should lead to the independence of the judiciary and other key institutions and the devolution of political authority. This is key for a genuine reconciliation and the full enjoyment of the human rights of all Sri Lankans. To this end, we call on the government to fully consider the numerous and consecutive recommendations by various UN human rights mechanisms. We also call on the government to conduct a transparent, open and inclusive public debate on the draft constitution before it is presented to the Parliament. The lack of substantial progress in the domestically driven accountability and reconciliation process further underscores the need for the government to also adopt and implement comprehensive transitional justice measures. To this end, we welcome the OHCHR's increased involvement in certain issues of the accountability process and recall the critical importance of securing the necessary budgetary allocation for its work. Thank you.
Gracias. Tiene la...
Thank you. I give the floor to the Democratic People's Republic of Korea.
Thank you, Mr. President. In our view, country reports before the Council often debates from the principle of objectivity and non-bias, relying on unverified and groundless information spread by media and dishonest forces for the sinister political purposes rather than information provided by the concerned country. Politically motivated pressure and biased approach is counterproductive that undermine the dialogue and cooperation for the genuine promotion and protection of human rights. We note with appreciation the sincere efforts made by the government of Sri Lanka for the promotion and protection of human rights in the country, despite many challenges. The community of nations must support any initiative in good faith that contributes to preserving reconciliation and stability in the country, or was acting with help in accordance with the decisions taken by the government of Sri Lanka, the sovereign state. We urge the HRC or OHCR to encourage genuine dialogue and cooperation with Sri Lanka, carry out the work based on its mandate in an objective and impartial manner, and stand against politicization, selectivity, and double standards of human rights. I thank you.
Gracias. Tiene la palabra.
Thank you. Give the floor to Canada.
Canada welcomes the High Commissioner's written update on Sri Lanka and the OHCHR's continued efforts with regards to the accountability process. We note with concern the limited meaningful action to address past and ongoing human rights violations since Council Resolution 46/1. The lack of progress since the release of the list of missing persons by the Office of Missing Persons is disappointing. Meaningful peace and reconciliation requires civilian-led governments, an independent judiciary, meaningful civil society space, and respect for human rights, democracy, and the rule of law. While we acknowledge proposed amendments to the Prevention of Terrorism Act, these do not go far enough to address long-standing concerns, including the persistent culture of intimidation and surveillance of NGOs, human rights defenders, journalists, and religious minorities, including recent arbitrary arrests of Muslims under the Prevention of Terrorism Act. Recently, human rights advocates have been targeted for expressing their views, and acts of memorialization by Tamils continue to be repressed. The human rights situation could deteriorate further as long as the underlying issues that drove division and led to decades of violence and conflict in Sri Lanka remain unaddressed. We encourage Sri Lanka to uphold its human rights obligations and engage constructively with the OHCHR. Canada believes Resolution 46/1 is a step towards securing a safe, peaceful, and inclusive future for Sri Lanka, and we stand ready to support efforts towards this goal. Madam High Commissioner, how can we collectively help advance accountability and reconciliation and end impunity in Sri Lanka? Thank you.
Thank you. Tiene la palabra Philip.
Give the floor to the Philippines.
Chair, the Philippines voted against HRC Resolution 46/1 as we disagree with the role being set for the OHCHR in collecting evidence and developing strategies for future accountability processes. The decision of the OHCHR to establish an accountability project is a breach of the text of the mandate and, in effect, a usurpation of the role of the state as duty bearer. We are not convinced that OHCHR has the mandate and capacity to carry out this so-called project with the highest standards of objectivity and professional rigor. The exorbitant cost of the mandate in the region of $3 million, mainly for the salaries of 12 new P-level UN staff for 1 year, has little to offer to concrete programs to strengthen national accountability mechanisms. We ask the Council to re-examine more closely the PBIs of country resolutions and to promote transparency on this issue. We acknowledge Sri Lanka's long history of constructive engagement with the OHCHR and the UN mechanisms and the government's efforts in pursuing reconciliation, accountability, and human rights through inclusive domestic processes. Noting the recommendations in the OHCHR report in areas of accountability, counterterrorism, civic space, what opportunities for collaborative technical cooperation between Sri Lanka and the UN are there, and how could this be informed by development realities and political complexities on the ground? Thank you, Chair.
Thank you. Tiene la palabra Nepal.
Give the floor to Nepal.
Mr. President, Madam High Commissioner, we thank the High Commissioner for the presentation of the report. We take note of the engagement of OHCHR and the government of Sri Lanka in preparation of the report. The engagement of Sri Lanka with the human rights bodies and mechanism, including the arrangements of visit of a special procedure, is commendable. We also appreciate the efforts of Sri Lanka in implementing the voluntary commitments to enhance cooperation in the field of human rights. To that end, we note Sri Lanka's efforts in promoting national unity and reconciliation, including the initiatives executed through the Office of Missing Persons, Office for Reparations, among others. Mr. President, in view of Nepal's own experience of a successful homegrown and nationally led peace process, we underscore that such aspects need to be given due consideration while promoting reconciliation, accountability, human rights, and lasting peace in Sri Lanka. We believe that the Council's work should be guided by the spirit of genuine dialogue and cooperation and should be based on the objective, non-selective, and impartial approach while refraining from the politicization of the human rights issues. Furthermore, the support of the country concerned is critical in the Council's efforts for the universal protection and promotion of human rights. I thank you.
Thank you, Ambassador. Tiene la palabra Kenya.
I give the floor to Kenya.
Thank you, Mr. President. Kenya takes note of the report of the High Commissioner for Human Rights on the role of advancing reconciliation, accountability, and human rights in the context of Resolution 46/1, adopted on the 23rd March 2021. We commend the government of Sri Lanka for the renewed openness and willingness in collaborating with the Office of the High Commissioner for Human Rights in implementing voluntary commitments in accordance with the Constitution and its international obligations. We note that these commitments are reconciliatory and therefore critical in unifying the country. We also recognize the role of the national institutions of Sri Lanka government in continuing to address matters relating to human rights obligations and encourage the government to continue pursuing full achievement of sustainable peace and reconciliation for its peoples. Kenya calls upon the Human Rights Council to continue with the constructive engagement and support Sri Lanka and the implementation of its national programs in order to achieve its domestic priorities for its development. I thank you.
Thank you. And now I give the floor to the distinguished Ambassador of India.
Thank you, Mr. President. We have taken note of the High Commissioner's report on Sri Lanka and her oral remarks. As its friend and immediate neighbor, India has consistently called upon Sri Lanka to fulfill its commitments on addressing the issues related to protecting the interests of Tamil in Sri Lanka. India believes that it is in Sri Lanka's own interest that the expectations of Tamils in Sri Lanka for equality, justice, peace, and dignity within a united Sri Lanka are fulfilled. This applies equally to the commitments made by Sri Lankan government on meaningful devolution, including through the 13th Amendment to Sri Lankan Constitution. We have taken note of engagements by the government of Sri Lanka with the members of the international community and other relevant organizations on various aspects of human rights situation and reconciliation issues in Sri Lanka. We would like such engagements and productive and purposeful dialogue to continue among the relevant stakeholders. The report raises important concerns on promoting reconciliation, accountability, and human rights in Sri Lanka. We call upon Sri Lanka to take the necessary steps to address the legitimate aspirations of the Tamil community, including by carrying forward the process of reconciliation and implementation of the 13th Amendment to the Constitution of Sri Lanka to ensure that the fundamental freedoms and human rights of all its citizens are fully protected. We will continue to urge the Sri Lankan government for the early conduct of elections to the provincial councils in keeping with its commitments to devolution of power. I thank you, Mr. President.
Et maintenant, je donne la parole à...
And now I give the floor to the Ambassador of France. President, High Commissioner, Madam High Commissioner, thank you very much for your report. Sri Lanka has been followed up by the Council since 2015 and the adoption of Resolution 31. During that time, there were a number of resolutions, discussions that have led to answers as a result of the violations of human rights and the process of reconciliation underway. This Council has tried to have a cooperative approach in order to assist the Sri Lankan government in order to put an end to the injustices and that have been outlined in a number of reports. France calls on Sri Lanka to continue and to further its cooperation with the United Nations, in particular with the OHCHR. This cooperation is absolutely vital in order to ensure better protection of the Sri Lankan citizen as to the violations that are all too numerous. And we have to ensure that the legal system gives the necessary protection. France welcomes the Prevention of Terrorism Act as proposed by the government. We suggest that this be continued, and we suggest that Sri Lanka continues to have an open and frank dialogue on the situation in that country. Thank you. Thank you, Ambassador.
This was the last speaker that we can accommodate at this meeting today. We've come to the end of today's meetings. We will reconvene on Monday at 9 in the morning to continue with the interactive dialogue on the written update of the Office of the High Commissioner on the situation of human rights in Sri Lanka, and to hold the meeting dedicated to intensifying technical cooperation and capacity building for the promotion and protection of human rights of persons in situations of vulnerability and marginalization in the context of the activities of the post-pandemic recovery activities. So with that, the 11th meeting of the 49th session of the Human Rights Council stands adjourned.
வணக்கம். நாங்கள் இப்போது இந்த 3046-1 ரிப்போர்ட், அதாவது இப்ப மார்ச் மாதம் வந்த ரிப்போர்ட்டை பார்க்க இருக்கின்றோம் ஆங்கிலத்தில். Promoting reconciliation, accountability, and human rights in Sri Lanka, report of the United Nations High Commissioner for Human Rights. The summary says that at present a written update is submitted pursuant to the Human Rights Council Resolution 40/1 OACHR present its observations on the human rights situation in Sri Lanka and continuing challenges for advancing reconciliation, accountability, and human rights. It focuses on the development since the High Commissioner's last report on Sri Lanka in February 21, including the broader trends identified at that time. The report also includes the update on steps taken to implement the accountability-related aspect of the resolution. The High Commissioner remained concerned about the continued lack of accountability for past human rights violations and recognitions of victims' rights in Sri Lanka, particularly those stemming from the conflict ended in 2009. She highlight continuing trend towards militarization and ethno-religious nationalism that undermine democratic institutions, create the anxiety of minorities, and impede reconciliation. At the same time, the High Commissioner recognizes the recent sign of renewed openness of the government in engaging with OACHR, that is really towards this written report, and to the March, these tick box exercises which currently, you know, that because of the situation, and they want to receive concessions like EU's USP Plus and other things, and they want to get loans, so they brought in two people, especially the foreign minister has been changed, and also they have brought in certain people just to work around for the time being. But these are all the things happened, and we had to think about it as a whiteboard exercise. So we'll look at it further. Increase in anxiety. Okay. At the same time, the High Commissioner recognizes the recent sign of renewed openness suddenly come of the government in engaging with the OACR. The initial step taken to initiate some reforms. The High Commissioner believes, however, that a comprehensive version for genuine reconciliation and accountability process is urgently needed, as well as deeper institutional and security sector reform will end impunity and prevent recurrence of violation of the past. This written update introduction, the written update is presented to the pursuant Human Rights Council Resolution 46/1 that requested the Office of High Commissioner for Human Rights to enhance its monitoring and reporting on the situation of human rights in Sri Lanka, including on the progress of reconciliation and accountability, to the present a written update on the 49th session. It is focuses on development since the High Commissioner's last report in Sri Lanka on February 21, including the broader trend she identified at the time. The report also includes an update on steps taken to strengthen the capacity of OACHR to collect, consolidate, analyze, and preserve information and evidences to develop possible strategies for future accountability processes, to advocate for the victim and survivors, and to support the relevant judicial and other proceeding, including in the member state with the competent jurisdiction. OACR appreciate the constructive engagement of the government throughout the preparation of this update. OACR sent a list of questions to the government of Sri Lanka on the 5th of October 2021 and received a written inputs on the 8th of December 2021, along with several updates. several later updates. Furthermore, the government agreed on an OSCHR delegation visiting Sri Lanka in January 22 for further consultation. However, this could not take place due to COVID-19 situation in Europe. Virtual consultations were held instead between OSCR and government counterparts on 24th of January, and OSCR met with range of other stakeholders. OSCR appreciate the open and substantive nature of these SSI exchanges. The report was shared with the government to provide an opportunity to comment. The special rapporteurs on contemporary forms of slavery, including its causes and consequences, visited Sri Lanka between 26th of November and 3rd of December. The government also agreed to the visit by the special rapporteur on right to education, which still to be scheduled on the 5th of February. Special procedures issued a joint statement recalling the key recommendation made by them following the official visit between 2015 to 2019. During 2021, special procedures issued 9 communications on Sri Lanka. The government had responded to 5 as of 14 February 2022. Context. Since Sri Lanka has faced several waves of COVID-19 pandemic, which have had a multidimensional human rights impact on public health and economic and social rights. Sri Lanka enjoys a free universal health care. The government has achieved a high vaccination rate and implemented various stimulus and economic support measures. Prolonged lockdown and travel disruption have nevertheless affected important sectors such as tourism, garments, services, and transportation, as well as decreased export earning. The remittances. Moreover, the policies to tackle looming financial debt crisis have led to various economic and social consequences, such as import restriction and depreciation of the currency and inflation in food and fuel prices. According to the World Bank, over 500,000 people may have been fallen below the poverty line since the beginning of the pandemic, which is widespread loss of jobs and work hours, mainly affecting the informal sector workers, micro, small, and medium-sized enterprises, with women making up a significant percentage of the workforce in the informal garments and textile sector. They have been disproportionately affected by jobs or loss of income. Many Sri Lankan migrant workers also lost their jobs in the host countries, affecting remittance income. The economic conditions have impacted on food security. The World Bank survey indicates that 44% of the households were concerned about the food. The introduction of the ban on use of fertilizers to promote organic agriculture, later reversed after protest, also impacted on food production. In August, the government introduced a new emergency regulation reportedly to curb speculative practices of the traders among high food prices, the shortages of some essential commodities which have now lapsed. The discontinuance of economic situations in government policies have led to protest. In response, the government has enforced COVID-19 measures, including quarantine law rules and other rules to limit the demonstration over difficult economic and social issues. In some cases, the arrest and charge protesters. Although the protests were peaceful, the government assert this was necessary for public health ground. On several occasions, however, the courts refused to grant injunction requested by the police to stop protesters, citing the right of freedom of expression or a peaceful assembly. In June 21, the police and media spokesman announced the Criminal Investigation Department had formed a special team to patrol the cyberspace and arrest those who spread false news on social media about COVID-19 other sensitive issues. The government also informed the OHCHR that drafting a new law on protection from online falsehood and manipulations. The High Commissioner encourages the government to take careful account and the observation made by the UN Human Rights Council mechanisms or laws of this kind, which can seriously impact on the exercise of the right to freedom of expression, opinion, and information, and to ensure that full consultation with the representative of the civil society, independent media, and formation of this law. Legal and institutional development affecting human rights. In her previous report, the High Commissioner warned of erosion of the independence of key institutions in Sri Lanka, particularly following the 20th Amendment to the Constitution that changed the appointment process of judiciary and independent institutions, including the Human Rights Commission of Sri Lanka. In November 2021, following the special review, the Global Alliances of National Human Rights Institutions recommended that HRCHL be downgraded from Human Rights Commission of Sri Lanka will be downgraded from A to B status on the grounds of lack of transparent and independent appointment process, lack of plurality and diversity, and failure by the HRCL, Human Rights Commission of Sri Lanka, to independently and effectively exercise its human rights mandate. As a retired Supreme Court Justice, Rohini Marasinghe was appointed as a new chair of HRCHL, Human Rights Commission of Sri Lanka, on December 21. The High Commissioner is also concerned about the independence of Right to Information Commission, which has made important rulings, may also have undermined the following appointment of a retired Supreme Court Justice, Upali Abhiyaradne, as chair, as highlighted by the previous report. Justice Abhiyaradne served as a chair of Presidential Commissions of Inquiry on alleged political victimization, on which they obstructed and intervened in judicial proceedings on several emblematic human rights cases. The High Commissioner also stresses the process now underway to draft a new constitution to be a fundamental importance on the protection of human rights in Sri Lanka, the independence of the key institutions, and devolution of power political authority, which the Human Rights Council has noted is integral to the reconciliation and full enjoyment of human rights by all members of the population. A committee of experts appointed by the government is working on a draft constitution, has invited public to provide comments. The High Commissioner urges the government to take into account the observation and recommendation made over the years by various United Nations High Commissioners human right mechanism with respect to human right and constitution in the constitution. She also urged the government to make the draft available to public consultation and debate before presented to the parliament. Militarization and land issues. As observed in the previous report, the past 2 years have seen an increase in the militarization of civilian government functions in Sri Lanka. The government justifies these appointments in terms of improving efficiency of being confirmatory within the law. The High Commissioner remained concerned, however, that the concentration of civilian positions in the hand of the military official affected the democratic governance, the long-term character of the state. In addition, the Ministry of Defense, current and former military officers, including some implicated in alleged grave human rights violations, now occupy positions of authority in several ministries, including Foreign Affairs, Public Security, Finance, Health, Wildlife, Forest Conversions. Although the Secretariat ruling NGOs have been transferred to Foreign Minister, the Ministry of Defense controlled at least 31 other agencies ranging from media to immigration. In August 2021, for example, Major General was appointed as a Commissioner of Essential Services to oversee implementation of emergency regulations to ensure food security and price control. In December 2021, Army Commander General Sarvendra Silva was appointed to implement the President Green Agriculture Operatives Center to promote and distribute organic fertilizers. The President continued to renew Gazette notification under Section 12 of the Public Security Ordinance, which authorizes recourse to armed forces in circumstances where the performance of police functions requires to be strengthened. Such order continued to militarize approach of law enforcement and expand to the role of military in policing function. The report indicates that this proportionally high number of military checkpoints in the northern provinces and complaints of discriminatory treatment or harassment during security checks, particularly for women. The release of the land occupied by the military, particularly in the northern eastern provinces, have been important element in peace building and reconciliation. The government reports that the number of private owned land released by armed forces from 2009 to October 2021 is 2,601,796 acres, or 92.42%, and further 53 or 0.91% acres proposed to be released. However, the renewed trend of land dispute relating to Buddhist heritage conversions and forestry protection have created new tension with minority communities, particularly in Eastern Province, give the diverse population a heritage of this region. Given the in June 2020, the Task Force for Archaeological Heritage Management in the Eastern Provinces, headed by the Defense Secretary, is working with the Archaeological Department, Mahavali Authority, Forest Department, Wildlife Department, Police, Military, and Buddhist clerics to identify archaeological monument to facilitate the repair or construction of Buddhist sites. The government have also imposed restriction on land use in these areas on the basis of environmental and forest preservation. Minority communities fear the program is being used to change the demographic landscape of the region. This could impact livelihood and increase potential for new conflicts. OSCR report recorded of 45 such disputes over land involving state actors and minorities between January to November 2021. For instance, around 40.33 acres of the land level location in the Kuruchaveli DS division of Trincomalee district was released out to several Buddhist trust temples for 30 years. In September 2020, media reported the archaeological development took over 358 acres of land in Tennamavadi, Trincomalee district, which was claimed by Tamil farmers after they were identified as archaeological sites. Increasing majoritarianism and on the reconciliation and peace building. In his address on the 76th session of General Assembly in September, the President affirmed the government's firm intention to build a prosperous and stable and secure future for all Sri Lankan, regardless of ethnicity, religion, or gender. However, the action by the government during the past year have reinforced the nexus between the Sinhalese nationalism, Buddhist, and the state, increasing the sense of marginalization and anxiety among Tamils, Muslim, and Christian minority communities, and undermining prospect for reconciliation. In October 21, the presidential appointed a presidential task force to mandate a formulate the framework on making recommendation for implementation of the concept of one country, one law promised in his election manifesto and present in a final report in February 2022, 28th of February 2022. Controversially, he appointed its chairperson, Buddhist monk Gnanathara Thera, the leader of a Bodhibala Sena, a Buddhist extremist organization known for its anti-Muslim rhetoric and hate speech. Gnanathara Thera has been accused of provoking anti-Muslim violence in the past. For instance, the riot of Algama in 2014 and Digma in 2018. In August 2018, he was sentenced for 6 years of imprisonment for contempt of court for separate incident, but received a presidential pardon in 2019. The constitution already recognized Sri Lanka as a unitary state and the equality of the citizen before the law, but the concept of one country, one law have implication for devolution of political authorities and lawmaking powers to the provincial level. It may also relate to the set of customary personal laws have been allowed different communities to retain specific practices, preserving the diversity of multiples of identities in Sri Lankan society. Today, these defined as Tesa Valamai law that applies to the Tamils in the northern province. The Kandyan law is the elective matrilineal and inheritance framework for Kandi Sinhalese, and the Muslim personal law. All three regimes inheritance framework, regimes deal primarily with the issue of property, including land inheritance, including the interstate succession and marriage and divorce, but also important to identify based symbolic values. Separately, the government informed OACR that Muslim Law Reform Advisory Committee appointed by the Minister of Justice made recommendation for amendment to Muslim Marriage and Divorce Act of 1951, General Marriages Ordinance and Civil Procedures Code to bring them into conformity with prevailing international standards. The legal draftman is now preparing the amendment. The amendment reportedly will inter alia introduce a minimum age of marriage of 18 years for Muslim, introduce a minimum educational qualification for the member of quasi court, and possibly the possibility of female members, and give Muslim a choice of registering their marriages under general law. The High Commissioner welcome any progressive reform that will strengthen the right of the women and girls in line with the international human rights standard, and encourages the maximum consultation with the Muslim community, in particular women. In 2021, new Buddhist temples statute and sign were erected symbolic location with the patronage of military and the government officials. On 18th of January 21, the State of Ministers for National Heritage and military officer inaugurating the Buddha statue erected despite the court order alleged on the site of ancient Hindu temple in Mullaitivu district. In November 21, the new monumental stupa of Anuradhapura, built with the support of the military, which was consecrated with the tribute to war heroes, reinforcing the narrative that despite the conflict in ethno-religious terms, the appointments in November 21 of a Buddhist monk as the Chancellor of the University of Colombo, the country's premier academic institution, was protested by the teachers and students as undermining secularism and academic independence. Several government figures have made policy proposals which would disproportionately affect Muslim communities. In February 2021, government revoked the forced cremation of policy of COVID-19 disease. However, the distant location of the burial site proposes the practical challenges for grieving families, as they must travel a long distance to perform their ritual. In March 2021, Public Security Minister Sarath Veerasagara proposed a ban on bugras and niqabs, starting such as veils and sign of religious extremism which affect the national security. The government has clarified the proposed ban on the face covering, which hinder the identities, would apply to all communities and both sexes. In October in 2021, the cabinet approved the proposal to ban cattle slaughtering in the country, an activity mostly conducted by Muslim butchers. Although these proposals have not been advanced or implemented, they have contributed to a climate of anti-Muslim rhetoric and added to the feeling and annihilation of the Muslim community. Incidents of attacks targeting Christian, evangelical, and non-denominational searches have continued to be reported, including intimidation and harassment of pastors by the public officers or members of other creed or disturbances at places of worship. Intimidation and threat to the civil society and victims. The patterns of surveillance and harassment of civil society organizations, human rights defenders, and victims highlighted in the previous report have continued, particularly for those in the country of Northeast. OACR continued to receive allegations of intimidation, monitoring, and surveillance by security services against human rights defenders, civil society representatives, journalists, families of the disappeared. The government stresses that all such complaints should be submitted to relevant national mechanism. CSO activities are regularly visited in their offices or homes or called by the police for inquiries and questions about the staff and donors, bank details of their foreign contacts, travel history, and their password for their social media account. For instance, in December 21, the Terrorist Investigation Division of Police called the staff of at least 4 organizations in Northern Province for inquiries and questioned them for their several hours. They were questioned to submit all information on their fundraising organization for the past years and details of the beneficiaries. The government asserts that such scrutiny is needed to combat money laundering and financing of terrorism. A range of restrictions have affected operating space for CSOs, particularly in the north and east. Organizations report being unable to work without surveillance or security, having to inform and get approval from the district secretariat for any activity. Some areas of the work that do not involve material or service delivery, such as psycho-social support, and are particularly discouraged. CSOs inform ACR that the banks often require them to get approval from their representative district secretaries before releasing the fund, placed on administrative hurdles for CSO. The High Commissioner is concerned by the government recent public report responses to the human rights advocacy by well-known and respected civil society representative and his counterflation with the LTTE propaganda. Similar interventions in the past have had a chilling effect on the Sri Lankan human rights defenders, including their interaction with the Human Rights Council. The High Commissioner notes as a positive development the transfer of the National Secretariat for the non-governmental organizations, which regulates CSOs, from the Ministry of Defense to the Ministry of Foreign Affairs in November 21, and hopes that it will lead to fundamental change in the current scrutinized approach, promote more enabling environment for civil societies. The government informed that it began consultation on the proposed revision and voluntary services registration and supervision Act 31 of 1980. OACHR received several reports that the victim group continued to face harassment and intimidation from authorities, including multiple visits from intelligence and police officers, inquiring plans for protest or commemoration of their past link with the Liberation Tigers of Tamil. In addition, rehabilitated LTT members and the families or anyone considered to have any link with LTT during the conflict are target for constant surveillance. The High Commissioner is concerned about gender dimension of these policies in context where many of these of those advocating for justice are women survivors or family members who face additional vulnerability in their dealing with the security forces and authorities. Civil society organization and victim group, especially those that are grassroots women-led organizations, should be treated as virtual partners in peace building, and they must be allowed to mobilize, advocate, and carry out peace building and reconciliation related activities. There were also cases of victim groups, CSOs, civil society organizations, politicians were prevented by authorities from holding peaceful event on commemoration activities in May 21, and police obtained court injunction against 27 individuals to prevent from organizing a commemoration of war in Mullivaikkal, although the court amendment restraining order for the next day. Lockdown was imposed on Mullivaikkal and surrounding area, and the military blocked the access road. In September 2021, the court issued restraining order on the leader of the association and families of disappeared to prevent them participating in rallies and meetings. And in December 2021, police obtained court injunction to stop an event organized in Kandy by the local human rights organization to celebrate Human Rights Day, citing it caused disunity among different ethnic groups. Custodial deaths and tortures and ill treatment. The Human Rights Commissioner welcomed the step that has taken to reduce prison overcrowding in the context of COVID-19 pandemic, in particularly release of pre-trial detainees on bail. As a result, the government report the prison population was reduced from 32,000 in October 2020 to 18,903 on February 2022. The Judicial Services Commission has issued directive to judges to increase the use of bail, and the Attorney General has also issued direction for the police to reduce incarceration of the people arrested for possession of user quantities of drugs. High Commissioner remains seriously concerned about the repeated incidents of death on custody and alleged armed encounter with police. For example, on the 6th of June, Muhammad Ali Khan, who had been arrested for the alleged cocaine valuation, died in the police custody in Watala Pola, Panandura, near Colombo. Police reported that he jumped from a moving police vehicle. However, the family alleged that he was beaten and killed by the police. Two suspects of Chandran Vasudevan and Rahman died within hours of their arrest in particular in June, and in Mannar in October 21 respectively, reported due to drug-related cases. On 18th of July 2021, a gang leader, Lalit Veeravansana Pindo, was killed by the Special Task Force reportedly when he was resisting arrest. On 11th of January 2022, Rajapaksa Mudiyalas Silage Manike died after falling out of the window from the fifth floor of Criminal Investigation Department building in the Fort Colombo, where she was being held over fraud allegation. According to the police, she committed suicide. High Commissioner is alarmed on at least 2 occasions on bar association and private lawyers have notified the authorities that the detainees' lives were at risk. For instance, on the November 16th, police killed Hawa Linkvi Lasanda in Kalutura when he was being escorted to recover firearm, allegedly used in another crime. He reportedly attacked the police officer. A day before, Lasanda's lawyers have corrected the Bar Association to inform that his client's life was in danger. The Bar Association, in its statement, confirmed that it has warned the Inspector General of Police and the Human Rights Commission of Sri Lanka about the risk and imminent killing and stated the incident as a hallmark of extrajudicial killing. In similar incident, Malon Mabula and Tarakara Peraha Veerasehara were shot dead on the 11th and 12th May, respectively, in New Navagamuwa and Minganawa, Western Province, while they was being escorted on detention to assist investigation. The government informed the OHCHR that the 9 custodial deaths occurred between 1st of January 2021 and 30th of November 2022. The 2 police officers were charged and 7 police officers faced disciplinary action in relation to custodial death, but it is not clear in which cases. The High Commissioner believes, in addition to attributing individual responsibility for crime and ensuring representation to the families in these cases, warrant independent investigation to identify patterns and command responsibility within the police service. Several allegations of ill-treatment, torture by the police also reported in 2021. The family of Chandran Vasudeva Vidu Sen, who died in police custody on the 3rd of June, reportedly of drug overdose, alleged that the police tied him to the tree and severely beat him with the poles before taking him away. Cases have also been reported of ill-treatment and torture by military personnel. For instance, on 22nd December 2021, fishermen alleged that he was severely beaten by Sri Lankan military officer in Jaffna. On the 27th of November, journalist was reported beaten by Sri Lankan military personnel while he was photographing the roadside name board on the Mulivaikal Lawyers for Prevention of Terrorism Act. Detainees have also reported tortures and ill-treatment during interrogation by TID in Joseph Camp, Evonia. It is widely reported in September 21, the State Minister of Prison Management and Prisoner Rehabilitation, Lohan Ratwe, forcibly entered a prison in Colombo with a group of his friends to show them the gallows, and later in a prison in Anuradhapura, where he alleged forced 2 Tamil detainees under the PTA to kneel at gunpoint and threatened to kill them. Ratwate resigned from prison portfolio but retained his position as a state minister for gem and jewelry. In what government highlight as a torture prevention measure, the Criminal Procedure Code was amended, requiring magistrate to visit police stations to at least once a month to personally see the suspect in police custody to check on whether he had been subjected to torture or ill treatment during and after the arrest. Concern have been expressed that this alternative inspection regime will be difficult to implement in practice due to limited time and capacity. Meanwhile, there has been no further progress toward establishment of operationalization of national preventive mechanism under the operational protocol to Convention Against Torture. The High Commissioner recalls the comprehensive observation made on Sri Lanka by Committee Against Torture in 2016 and urges the government to take concrete steps to implement those recommendations. Prevention of Terrorism Act. On the 10th of February, just before this month, this is again the Sri Lanka's the tick box exercises of whitewashing. They said on 10th of February before the 28th, when the Human Rights Council is starting, they are doing certain things. This is a ritualistic things. They do it every human rights session, which Sri Lanka under the spotlight, they will start doing this. So this is clearly one of these exercises which Sri Lanka always do and get a good report and get away with murder. So on 10th of February 2022, Prevention of Terrorism Act amendment bill was presented to the Parliament. This government informed the initial step towards promulgation and more comprehensive legislation, where the Human Rights Council has asked to take out the legislation altogether. So now they are changing the legislation and making tinkering on the side, tinkering and saying that, oh, we have tinkered, we are changing. And the High Commissioner recognizes the importance of initial step towards TEP and not propose amendments such as increase of magistrate powers to visit places of detention, speeding of trials, as well as repeal of the Section 14, which imposes serious limitations to publications. However, other parts of the proposed amendment do not comply fully with Sri Lanka's international human rights obligation and leave intact some of the most problematic provisions of the PTA, which have led to alleged human rights violations, including arbitrary detention and torture. These include the overlay, broad, and vague definition of terrorism, which may result in discriminatory or arbitrary application of the law, and admissibility the confession and admissibility of confession under PTA made to law enforcement without lawyers present, often used as primary evidence in the courts in PTA cases. Lengthy administrative and pre-trial detention up to 12 months and provisions of impunity of the provisions for impunity of officers for prosecution which are not compliant with the international human rights standards. So this is again the Human Rights Commissioner has highlighted and what tinkering the Sri Lanka is making on the 10th of February. And these are all tick box exercises. The High Commissioner urges the government of Sri Lanka and the Parliament to give a full consideration and analysis to the recommendation made over many years by UN Human Rights Council on PTA. In particular, 5 key breaches benchmark identified by 7 procedure mandate in their communication on the 9th of December 2021, which they consider necessary prerequisite to ensure the PTA is amended with the compliance with the international law obligations. Meanwhile, the government continued to detain, investigate, and prosecute individuals under this act. The High Commissioner reiterated that her call the government to apply a moratorium on the use of PTA until it is replaced by a legislation that is fully complies with the country's international human rights obligation, according to the government data. As of the 2nd of December 21, 333 people detained under PTA, of whom 16 were convicted, 11 were under appeal, and remaining are detained as suspect. Since 24th June 1981, PTA detainees has been released among 81 since 24th June. 81 PTA detainees have been released. Among prominent PTA cases, Ansar Jasmine, detained for 18 months under PTA, was released on bail on the 15th of December. His Hasbullah, a lawyer who had detained under PTA since 14th of April 2020, was granted bail by the High Court on the February 2nd. These are the 2 things they did to just show the world that we are very, very nice people. In June 2021, the PTA prisoner, 16 PTA prisoners nearing end of their sentences were released under presidential pardon. On 24th of August 2021, the President appointed a 3-member advisory board headed by the retired Chief Justice to which detainees or representatives could apply for review. The report indicates that at least 70 people have been arrested under PTA for sharing social media posts commenting on their victim of war, including LTT images or Tamil nationalist iconography. On 18th of May, police arrested 10 people near Batikulova under the PTA for organizing a memorial event. They were finally released on bail on the 8th of December. A journalist, Murugapillai Koguladasan, had been detained for 15 months since November 2020 in relation to a photo of LTT leader appearing on his social media. The government shared with OASIA a directive issued by the Inspector General of Police on the 23rd of October 2021, providing guidance on restricting the use of PTA and exercising greater discretion in evaluating cases as possession of pictures. In March 2021, new de-radicalization regulations were issued to permit arbitrary administrative detention of individual up to 2 years without any legal proceeding for the purpose of rehabilitation in relation to violent extremism. The Special Rapporteur on the Promotion, Protection and Human Rights and fundamental freedom while countering the terrorism, and other experts have warned that the regularization may jeopardize the right and liberties of the person who may be detained arbitrarily, especially on religious and ethnic minorities, may curtail political dissent with no effective due process guarantees. Civil society organizations obtained a stay order on implementation while the Supreme Court considers fundamental petition against the regulation. Transitional justice mechanism, progress on reconciliation and accountability. Transitional justice mechanism. When the government decided to withdraw its co-sponsoring of the resolution 40/1, that later resolution 34/1 to 34/1 and 30/1 expressed its intention to pursue inclusive, domestically designated and executed reconciliation and accountability process. 2 years on, government has yet to come forward with any credible new roadmap on transitional justice towards accountability and reconciliation. The Commission of Inquiry appointed by the President in November 2020 review reports previous Sri Lankan COIs assess the status of implementation of the recommendation and the purpose of deliverable measures to implement them in line with the new government policy. Submitted a second interim report to the February 22. The transitional justice established by the previous government, the Office of Missing Person and Office of Rehabilitation, continue to exist. However, they have struggled to achieve the confidence of victims, particularly following changes in their membership. In December 2021, a new chairman and commissioner have been appointed to OMP. According to the government, OMP have been working on verification of 6,025 complaints it has received for in the first phase of 2000 to 2020, have shared 6025 families with the relevant authorities to obtain additional information. The OAP determined 4,200 complaints required further documentation, has notified 3,230 families to provide further details needed to process their cases. The government reported in November 21, the OMP established 4-panel inquiry to conduct investigation and enable OMP to issue certificate of absence or certificate of death families. The ACR is concerned that the verification seemed to aim at reducing the case load and closing files rather than comprehensive establish to comprehensive. This is a very important sentence. That OACR is concerned that the verification seemed to me aimed at reducing the caseload and closing files rather than a comprehensive approach to establish the truth and ensure justice and redress of the families. The High Commissioner is gravely concerned about the continuing precarious situation of families of the disappeared, the majority of whom were reported represented by women. In addition to the suffering and anguish in not knowing the fate and whereabouts of their loved ones, they continue to struggle with the desperate economic and social consequences this had on their lives. COVID-19 has increased economic hardship for them and increased their isolation. In this context, the harassment and surveillance by the security agencies and the obstruction of their activities only compound the injustice they face. The families of the disappeared have the right to truth, justice, reparations, and guarantee of non-recurrence. The High Commissioner urges the government to acknowledge their suffering, urgently determine the fate or whereabouts the victim to provide and bring perpetrator to justice. That's not going to happen because the perpetrator, the leader of the perpetrator is the president. In 1921, President and the Prime Minister of Sri Lanka at present. In 2021, the Office of Reparations were allocated 800 million USD, 3.96 million for the payment of process claim. Out of that, 400 million was utilized according to OFR. Unfortunately, the data available to OSCR regarding the compensation payment is not sufficiently disaggregated. It is unclear what payment correspond to the human rights violation. The reparation policy was tabled to the Parliament on the 9th of February. The government informed OSCR that OFR developing pilot program for livelihood and psychosocial support. So again, the government is putting the money in their pocket. 52. The Office for National Unity, Reconciliation have continued to conduct peace and reconciliation workshop and activities throughout the country. So why they are doing that throughout the country? I can't understand. In the ONUR is reported to be developing strategic roadmap for national healing, peace building, and reconciliation through consultation process with civil society, political parties. The High Commissioner stresses that reconciliation will only be achieved when supported by the comprehensive transnational justice measures, and call the report of the very meaningful national consultation already held by the Consultation Task Force on Reconciliation Measures in 2017 that remain important guidelines as expectation of victims and the other stakeholders. Impurity in emblematic cases. The High Commissioner is seriously concerned by the continued lack of progress in even step back in several emblematic human rights cases before the court. In August 2021, Attorney General Department decided not to proceed with the charges against former Navy Commander Vasantha Karanagoda in the case of enforced disappearance of 11 individuals in 2008 and 2009. Karnagoda has filed a writ with Court of Appeal and secured a stay order as interim relief on the basis as he was wrongly implicated. The victim families challenged the decision in the Court of Appeal with the hearing expected on the April 2022. While the hearing on the case is set to continue against 14 other Navy personnel, Karnataka was meanwhile appointed as a governor of Northwestern Province in December 2021. In January 2021, the Attorney General informed particular High Court that it will not proceed with the prosecution of 5 accused in another emblematic prosecution of 5 accused in another emblematic cases of murder of MP Joseph Parraisingam at Christmas Mass in December 2005. In January 2022, the Colombo High Court delivered a judgment in case of 3 officers charged with 33 counts, including murder and conspiracy to commit murder for the incidents that resulted in a death of 27 inmates in Velengada prison riot in 9th of November 2012. The first accused Inspector of Police on January 2022, the Colombo High Court delivered a judgment in case of 3 officers charged on 33 counts, including the murder and conspiracy to commit murder for the incidents that resulted in death of 27 inmates in Velengada prison riot on 9th of November 2022. The first accused Inspector of Police Neomal Raja Rangavijiva of the Narcotic Bureau was acquitted of all charges. The second accused, former superintendent of Velikada Magazine prison, Link Lammahive Emil Ranjan, was found guilty on and given death sentence. The third accused, Indrajit Sambat, a officer attached to the prison and intelligence unit, was absconded and will be tried in absentia. No actions appear to have taken against other security forces involved in the incident. The victims of 2019 Easter Sunday bombing and religious leaders continue to call urgently the truth, justice and reparation for the victim and the full account of the circumstances that permitted those attacks, in particular the law of security establishment. The full result of the Presidential Commission of Inquiry into the attack have not been made public, but understood that the recommended criminal charges against key officers on the 4th of October 2021. Charges were served on 25 suspects in 2019 Easter Sunday bombing. The High Court is pending. Charges have been filed in the Court of Colombo, Hegali and Puttalam in 8 such cases. The church community was recently disrupted by the serious incident on 11th of January 22. The St. Anthony's Church, Borala, have an unexploded hand grenade discovered in the church days before the interfaith event was due to be held as a part of the campaign for justice. The police have made initial arrest of some people present at the church, but the investigation to date has been criticized and inefficient and incomprehensive. While hearing continues to be scheduled in several other emblematic cases highlighted in the previous report, the High Commissioner is concerned that the cases continue to linger before the courts for a decade or more after the original indictment. The Attorney General's recent use of his discretion to withdraw those long-standing cases raises serious concern about the independence of his office and the government's commitment to pursue accountability. The High Commissioner is deeply disturbed by the general lack of progress over the past years in most cases and active reversal of others, which continue to indicate the inability and unwillingness of the government to prosecute and punish perpetrators of the crime when the state agents were alleged perpetrators. Implementation of other aspect of resolution. In the absence of progress towards accountability by domestic mechanism, Resolution 46/1 decided to strengthen the capacity of OACR to collect and consolidate, analyze and preserve information of evidence and develop possible strategies for the future accountability process to advocate victims and the survivors, to support relevant judicial and other proceedings, including in the member state, with the competent jurisdiction. The accountability mandate present an important opportunity for OHCHR members of the Human Rights Council and the international community to support victims and pursue accountability for serious international crimes committed in Sri Lanka through complementary strategies. The office started implementing aspect of 46/1 with the startup team undertaking preparatory work since April 21, 2021. The office have now recruited more staff who included specialists on international crime and human rights law, humanitarian law, sexual and gender-based violence victims' rights, and information management. However, the start date of different members of the team will be further constrained by the budget allocated in 2022, for 2022. The office published online introductory material on mandate under the resolution today into question and answers translated in Sinhala and Tamil languages. The office has now developed information and evidence repository using e-discovery software that has identified large number of individual information items already held by UN. The team will further analyze the information for criminal justice perspective with a view to identify gaps and priorities for further information collected, incorporating victim-centered approach. The information held and gathered relates to the alleged violations, abuses by both state and non-state actors. The High Commissioner previous report recommended that among the range of measures, the member states should explore possibility of targeted sanctions against credibly alleged perpetrators of human violations and abuses. On 10th of December, the United States government announced that 2 Sri Lankan military officers implicated in great violations would be designated under the 7031C of Department of State and Foreign Operation Relations Program approach to inalienable to entry to the country. While the High Commissioner will report on further progress on the subject in September 22, it is clear that the scale of work for District 1 is substantial. Full implementation and mandate will require effective cooperation by the member state alongside adequate human and financial resources. Conclusion. The High Commissioner remained concerned about the lack of accountability for the past human rights violations and recognition of victim rights in the last 2 years. The independence of judiciary and human rights commission and other key institutions have been eroded, and democratic space, including the human rights advocacy, is constricted. These have been further drift toward militarization and emphasis on single nationalism and Buddhism in state institutions have become more visible, increasing marginalization and uncertainty of minority communities and undermining reconciliation. The forthcoming constitution drafting process will be critical importance for the independence of key institutional issues and issue of devolution and human rights should be monitored closely. The situation has been affected by deep impact of COVID-19 pandemic and the economic crisis, which has affected the realization of economic, social, cultural rights, and the government response to the criticism and dissent with the heavy-handed measures have undermined civic space. There are also risks that the economic downturn will further fuel prevailing marginalization, discrimination against the minority communities. High Commissioner recognizes the recent signs of renewed openness of the government in engaging with OSCR and the initial step to initiate some reforms, including changes to the Prevention of Terrorism Act. She urges the government to go much further and deeper with legal, institutional, and security sector reform that is necessary to comply with Sri Lanka's international human rights obligation and prevent recurrence of grave violations. OSCR continue to stand ready to assist Sri Lanka on this path. The High Commissioner is deeply concerned by the continued obstruction and setbacks path. The High Commissioner setbacks in most of the emblematic human rights cases that reached the court and the harassment of victims and the families of disappears campaigning for truth and justice or seeking to commemorate their loved ones. While the government emphasizes on practical measures of reparations and development as the basis for reconciliation, the High Commissioner stressed this will not be achieved without comprehensive approach to ensure truth, justice, redress, and victims and institutional reform that guarantees non-recurrence. The Sri Lankan state, including successive government, have consistently failed to prosecute international crimes and serious human rights violations to pursue an effective transitional justice process. The current government has continued to demonstrate its unwillingness to recognize those serious international crime and pursue accountability, but also incorporated some military officers who have been implicated in alleged war crimes into the highest level of the government, reinforcing the narrative of the impunity in the absence of tangible result that ensure justice for victims. The Human Rights Council should continue to pursue international strategies for accountability. The Human Rights Council and its special procedures, treaty, international mechanism, civil society organization, government-owned domestic commissions, lesson learned and reconciliation have put forward many concrete recommendations to the government to improve human rights situations and address legacy of the past. This recommendation should be used as a benchmark by the government as well as the international community. The United Nations is in advancing reconciliation, accountability, and human rights. OSCE stand with to support the Sri Lanka and to provide technical assistance in regard to Sri Lanka will not achieve sustainable development and peace, lasting reconciliation if it ensures civic space, independent and inclusive institution to put end of the systemic impunity. The recommendation of the High Commissioner. The High Commissioner reiterate the recommendation made to the government of Sri Lanka in the paragraph 60 of a 2021 report to the Council, and further recommend the government to ensure drafting and processing a new constitution based on a broad and inclusive consultation, enriches independence of judiciary, key national institutions such as Human Rights Council of Human Rights Commission of Sri Lanka, and advances the devolution of political authority, which is integral to the resolution, reconciliation, and the full enjoyment of the human right by all members of the population. Take into account the recommendation made by various UN human rights mechanism on the protection of human rights in Constitution and the guarantees needed for an effective, independent and inclusive national institution. Avoid reliance on the military to run civilian affairs, to take steps to reduce the influence of military in civilian life. Ensure that the Attorney General Department is able to operate independently in practice of pursue prosecutions against any suspect or perpetrators of human rights violations, serious violations of international human rights law, and respect of military ranks officers and their positions of power. Take comprehensive approach to determine the fate and whereabouts of the disappeared, including immediate opening military activities relevant to cases of enforced disappearances, independently investigate all those suspected of criminal responsibility for enforced disappearance, and provide a comprehensive reparation to the families of disappeared. Publish the finding of Commission of Inquiry into 2019 Easter Sunday bombing to ensure the transparency of victims and pursue further independent investigation into the involvement of other non-state or state or non-state actors. Undertake more fundamental reforms to the Prevention of Terrorism Act to ensure it fully complies with the Sri Lanka's international law application. In meantime, establish a moratorium on the use of Prevention of Terrorism Act until it is replaced by a legislation that is fully complies with the international human rights norms and standards. Expedite the review of all detainees held under the PTA and release everyone detained without sufficient legal or evidentiary basis. Ensure that counter-terrorism measures do not undermine democratic and civil spaces. Ensure the inclusive, broad-based consultation in drafting and amendment to the key laws, including the Prevention of Terrorism Act and Voluntary Social Sector Regulation Act, Muslim Marriage or Divorce Act, and other personal law, in order in all security agencies immediately to end all forms of surveillance, harassment, and repression against the human rights defenders, social actors, and families and human rights violation. Adjudicate the land dispute that are transparent, consultative, impartial, non-discriminatory to ensure the interfaith dialogue with the erection of religious site. The High Commissioner reiterated the recommended she made to the paragraph 61 of a 2021 report to the Council and member state further recommendation that they cooperate with the victims and their representative to investigate the prosecute international crimes committed by all parties in Sri Lanka through judicial proceeding in domestic jurisdiction, including under accepted principles of extraterritorial or universal jurisdiction, and continue to explore possibilities or possible targeted sanctions against credibly alleged perpetrators of grave human rights violations and abuses. Review asylum measures with respect to Sri Lankan nationals to protect them facing reprisal and reforms, refrain from any enforcement in cases to prevent real risk of torture and other serious human rights violations. Cooperate with OSCR accountability related work under what is provide adequate human rights resources to enable effectively to deliver full mandate under resolution. High Commissioner recommends to the United Nations entities scale up their protection work to prevent threat against the increase and support civil society organization firmly development, ensure strict, coherent and expanded application of human rights due diligence and principles in engagement with the security forces and all bodies under the preview of Ministry of Defense and Ministry of Public Security, review their engagement with and advice from structures of independence have been undermined, such as Human Rights Commission of Sri Lanka. Advocate with government of Sri Lanka to address the concern of the Global Alliance of National Human Rights Institutions to ensure the independence of Human Rights Commission of Sri Lanka. While fully understanding force generation challenges, context of United Nations peacekeeping given current circumstances, the Human Rights Commission of Sri Lanka review the contribution of Sri Lanka to the United Nations peacekeeping operation while screening the Sri Lankan personnel. So this is a report published. So with that, today's இன்றையான் இதை முடித்துக்கொள்வோம். தமிழரின் தலைவிதி தமிழரின் கையில், தமிழரின் தாகம் தமிழான தாயகம் என்று